Welcome, everybody. This is the first roundtable of this series of 3 roundtables on thematic roundtables that will, let's say, close the second module of our training. The idea, let's say, behind these roundtables is to try to offer you, to give you some insights on specific and relevant issues that regard migration and asylum policies of specific EU member states. We basically choose the member states that we, the national context that we already analyzed in previous in the previous lessons of these modules, or that have specific features that we think are of particular interest and importance. And that's the case of Greece that we will see in the next two roundtables. Today's discussion is dedicated to administrative detention and the other forms of confinement of migrants and asylum seekers, of people on the move in general, in 3 national contexts that are Germany, Italy, and Spain. We have 3 speakers today. First, I will introduce them very quickly. First one is Bian Sukhov. I hope I didn't mispronounce your surname, who is director of the Bucerius School Law Clinic and also co-initiator of the aid initiative for people detained for deportation in northern Germany, and chair of the advisory board of Refugee Law Clinics Germany. And then we have Maurizio Veglio, who is also a friend of us. He is an immigration and asylum lawyer, an expert lawyer on migration and asylum in Italy, member of the Association for Juridical Studies on Immigration, which is the most important and network of lawyers specialized in immigration law in Italy, and he's also lecturer of the International University College of Turin, in particular of the legal clinic on asylum at the International University College of Turin. And then, last but not least, Diego Boza Martinez, that you already know because he already gave, I think, 3 or 4 lessons in the training, who is a law professor at the University of Cadiz in Spain and member and a coordinator of the Asociación Pro Derechos Humanos de Andalucía, APEDACEA, that is partner of the project and is playing a key role in the implementation of this training course that is the first, let's say, activity of the project. I thank you all for having accepted this our invitation and for being with us. And as we said before, I leave the floor to Diego for his, let's say, overview of detention practices of people on the move in Spain. Thank you.
Okay, thank you very much. I'm very happy to be here again and to speak with this partner to show the situation of Spain about detention centers. I have a presentation, but I think I will go slow. I will go quickly through it because I only have a quarter, 15 or 20 minutes. So the first thing in Spain, we speak about CIES. CIES are Centros de Internamiento de Extranjeros, that are our migration detention centers. It's acronym in Spain, and those are the places where immigrants can be deprived of their freedom of movement. This arrest could last up to 60 days and is aimed are deporting the immigrant. In this sense, Spain has this kind of migration detention centers from 1985. This is the moment in which the Spanish legislation introduced this kind of centers. Those centers has been very problematic in Spain. I think in all the European countries, but in Spain they are a little bit special because of the situation and the conditions of geographical conditions, socio or economical geographical conditions of Spain. In this sense, we have another center, another special center. I'd like to make some reference to it, that we call Centers for Temporary Stay of Migrants. This is another center. It's called CETI, and we have two centers of this class in Ceuta and in Melilla. You know, Ceuta and Melilla are two Spanish cities in Moroccan territory. So it's a little bit special because these CETIs, it's the acronym in Spanish, are not compulsory. So people there are not deprived of freedom of movement because they can enter and exit freely. With this, the situation is that those centers are in the cities of Ceuta and Melilla, and to cross from Ceuta and Melilla to the rest of Spain, to the continent, you have to pass through the Schengen control. So in fact, you are not in Schengen territory. This is a thing to discuss, but you are not in Schengen territory. You have to pass another control. So the only situation, the only possibilities for people that are in these cities are remaining in Ceuta or Melilla, depending, and being there with the conditions to be in these cities that are poor cities and with not easy life conditions, or staying in a city. In this sense, we have noticed that people has been there. Some people, Bangladeshi people, is I think as long as I know, is the record has they have the record. They has been there for 2.5 years. So they are not detention centers, but in fact, they work as detention centers because these migrants cannot go to other places than coming back to Africa. I think not logical for them, or remaining in Ceuta. So some people has been there 4 years and until 2.5 years. It's in fact, there is no maximum stay in a city. Well, I will pass through this video, and I established that in Spain now there are 8 official CIEs in this moment. In fact, there are 9, but the Centro in Tarifa is linked to the center in Algeciras, so it's the same, but physically they are not the same. They are in two different places. In this sense, you can see that centers are in big cities, are Madrid, Barcelona, or Valencia, and in the southern border. So, in fact, these detention centers has been used as a migratory resource to control the migration. So it's a little bit tricky in this sense because, in fact, most of people that have passed for this, that have been in these centers, have been people coming from Africa directly. So in some years, the situation was that people arriving to the Andalusian coasts, to the Spanish coast, also to Canary Island, they were sent immediately to a FIE. So this is the element to control the irregular entries in Spain. In fact, this has changed a little because Spain has entered into the system a new center called CATE. The CATE is another center, Centro de Atención Temporal de Extranjeros, attention temporary center for migrants, but in fact there are not attention centers, there are detention centers, because in those places are more or less we can say our Spanish hotspots. To avoid that, using FIEs as a migration, as an entry resource, the Spanish government has created these CATES used to distinguish between people coming from Morocco, from Algeria, because they have Spanish has agreements with those countries, so it's easier to send back these people to Morocco and Algeria, and so those people coming from these countries go to the FIEs, and the other people coming from other countries or from other African countries remain in these CATES and go to other places as public resources, as NGOs, to be there not as detained but as free people. So this is the situation in this moment. We have three kinds of centers: FIEs, CATES, and FETIs. So FETIs are not detention centers, but in fact they work as detention center because they are on Ceuta and Melilla, and people can go to other places. CATES for people arriving, so they are they are at the ports waiting for people coming on boats, and they are the police detain them there and distribute them between FIEs and other centers, and last CS that are designed for expulsion, so for deportations. So this is the main point of FIEs. They are aimed for deportation. In this sense, for us, is very important to have in mind that Spanish Constitution doesn't allow any deprivation of liberty established by the administration. Only criminal courts can deprive liberty. So the freedom of people can detain people for more than 72 hours. So in this sense, the constitutionality of FIES have been put into discussion and went to the Constitutional Court in 1987. So in the very beginning of the establishment of this kind of centers. And Constitutional Court said that FIES are constitutional if, so the Constitutional Court established a decision, an interpretational decision. So it's not unconstitutional, but it depends on the conditions. And Constitutional Court established three conditions. First condition is they do not have penitentiary character. So it's the requirement, the first requirement of the Constitutional Court. But in fact, it's not true, in the sense that for example, Algeciras CIE is the old prison, and this old prison has become obsolete for criminals, but it's used for migrants. So the Constitutional Code established that they can have penitentiary character, but in fact they are in some cases also the same. Can be said about Malaga CIE that now is closed. Those are prisons that have become CIEs because of they are not useful for criminal. So it's a point to consider that this requirement is not accomplished in this moment. The second requirement was that every singular internment, not the general system, but every singular internment is must be approved by a judge respecting migrants' defense right. In this sense, it's true that we can say legally, or we can say theoretically, every single internment is approved by a judge. But if we control the figures, we can say that the average of judicial decision approving the internment is very high. Is when the public prosecutor asks for the internment, 90% of internments asked by public prosecutors are accepted by judges. Public prosecutors are not so successful in any other field of their activity. So it's very important to have in mind that, because it's not a real control, it's not a real approval, it's a decision that is taken before of the judicial decision. And also there is another problem, because there are criminal judges deciding that, but in fact some of the cases are administrative procedures. So in this sense, criminal judges are not so habituated to the logical, to the content of the administrative procedure. So in some cases, they are not, they do not solve adequately this kind of situations. And also the third condition is that the internment is only aimed at deporting the migrant. So in this sense, internment every internment has a limit of 60 days, but the Constitutional Court established that they cannot last more than necessary. So when police that control the internment centers, when police realize that they cannot deport the migrant, they have to release him. So this is a very important point, but because the figures show that most of internments last up 60 days, even when migrants are not deported. In fact, this is another important point to have in mind, and perhaps it could be one of my last points, is that more or less only 60% of migrants that go to an internment center are deported. And also, most of the deportation, half of the deportations in Spain are not executed from internment centers, are executed from other points. So, in fact, in Spain, detention centers for migrants are not will not pass efficiency control, because they're not useful for anything. They're only a point in the system, we can say a picture of the system to show outside, to show migrants that we are very severe with them, because they are a center to them to make them there, and also into the system, because it's also a message for Spanish population saying that we are not, we do things against these illegal migrants, these irregular migrants, in the sense of the public speech, in Spain. And in this sense, this message is also very important to criminalize migration. So because there are centers for detention, so in the same sense of prisons, not prisons, obviously, because they are administrative detention, but for general public, the consideration is that illegal migrants are detained in detention centers because they are dangerous. So it's a very important point to have in mind, that the role of these detention centers in Spain are not for a practical role, but is a symbolic role, in the sense of establish this kind of limits and this kind of message for internally and to the migrants. In this sense, well, this is a little bit explication about the Spanish system, but I think well, you have read about the expulsion and which is the system in general. And also, I think there are another point. Well, it's also FIEs are no-law places in Spain. Detention places are no-law places, in the sense that Bruno and Gambin explained, because in each FIE there is a scandal. So there is something wrong has happened in each Spanish CIE. We can do a quick overview. For example, in Madrid CIE, Sama Martinez died even when she asked several times for medical assistance, but because it was on holidays, there wasn't medical assistance in Madrid CIE, so she died even when she was ill and nobody diagnosed her before. Also, something similar happened in Barcelona CIES. Idrissa Diallo died from heart failure, also asking before medical assistance, but nobody paid him attention. And also, for example, in Valencia CIES, several NGOs established that patients or AIDS patients didn't receive their medication. So, and there are also another deep human rights violation in Valencia CIES related to the conditions of the detention, the conditions of the quality of food, etc. Also, in Canarian CIES, government didn't allow deputies to enter in Las Palmas, and also when during the pandemic, the COVID-19 spread deeply through the Canarian CIES, but the government didn't open this, didn't close in this sense, didn't avoid the detention in these centers until 20 days before the declaration. And also, perhaps the worst thing was in Malaga CIES. in this theory, female immigrants denounced sexual offenses from policemen working in Malaga theaters. According to the videos, because there are some videos, and according the denounces, there were sexual parties between female migrants and policemen in the theater. And when women accepted this kind of relationship, received better treatment. In this sense, in fact, Malaga theater was closed because of that and other relevant problems. But the fact was that policemen couldn't being judged because, or couldn't be condemned because female immigrants that had denounced this situation were deported before they went to the court. So as we can say, theaters are no law spaces, no law centers, and we have several establishments, and detention is going more and more important to control or to establish the rules about to manage the migration in Spain.
Thank you, Diego. I think it's, I feel that it's very important to stress this last point that you were making about, let's say, the widespread violations of human rights in detention centers, which is something that it's, like, I would say, a common feature of all detention centers across Europe and also elsewhere. And I think it's also these things that you said about the Constitutional Court, the decision of the Constitutional Court in Spain. I think that I see very relevant similarities with what the Italian Constitutional Court said about administrative detention in Italy in some years later, in 2001, if I'm not wrong. So I will pass the floor to Maurizio for his overview of the Italian detention center.
Thank you very much, Carlo. Can you hear me? Okay. Si. Thank you very much. I will try to exploit my 15-20 minutes in the most effective way if possible, trying to take advantage of Diego's presentation, since the main features of the Italian framework on administrative detention are basically the same as Spain, very much similar. So there are just some slight differences that I would like to highlight in a second. But let me say that the overall structure and the architecture of administrative detention in Italy is basically the same as Spain. We do have three possible categories of people that can end up in detention, of foreign people that can end up in detention, migrants that need to be identified in case they refuse several times being fingerprinted, so they refuse to put their hands on the scan to be identified through fingerprints. They can be detained into hotspots where built with the specific purpose to discriminate among people who want to apply for international protection, asylum seekers, and those who do not want to apply for asylum for asylum. We do know that most of people that entered Italy had a common purpose to transit the country and to move north to Germany and to Scandinavian countries and to France. So hotspot were somehow the filter that the European Commission forced Italy and Greece specifically to build in order to force people to leave their fingers in order to be able to, let's say, hinder secondary movement towards northern and central countries in Europe. Well, based on the assumption that the Dublin regulation would have prevented people from presenting international protection application in other countries. We do know that the Dublin regulation is a failure, and secondary movements do take place, but definitely after the launch of hotspot system back in 2015, the system has been, well, chances of crossing the border, the internal border within Europe were more difficult. And as a result, people do keep on moving around countries in European Union space, but at a higher place, at a higher cost, with more difficulties and more struggles. Asylum seekers, I just mentioned, can be detained in pre-removal detention centers, something which should not surprise, since the European directive is actually providing this chance. What is surprising to some extent is that the regulation for detention of asylum seekers is a punitive one. We'll see in a second that the maximum length of detention is 12 months, whereas the maximum length of detention for undocumented migrants, the third category of people that can end up in a pre-removal detention center, is 4 months. So a third of the maximum length of time foreseen for asylum seekers. Hotspots in Italy are 4, capacity do not exceed 1,500 people. Full theoretical capacity, then we know that in real terms, real capacity is usually lower for a number of reasons, while pre-removal detention centers are 10 in number, and capacity is, let's say, moving between 500 to 600 places. So in order to be detained, a migrant has to be notified, has to be issued a deportation or a removal at borders order from the authority, from the police. Whenever the immediate return is not possible, which is basically always the case, only a tiny share of people get immediately deported. The second chance is to be detained at a pre-removal detention center. Do remember that numbers are quite low in terms of capacity, so the vast majority of people receiving a deportation order or a removal at border order just end up in this chain of procedure with a 7 days order to leave the country that in most cases will not be complied with from the people. So it's, again, a system which is not working. For those ending up at pre-removal detention center, the detention has to be validated by a judge. Diego was mentioning that in Spain, it's a criminal judge in charge for this kind of validation. In Italy, is not it's a civil judge, but with a very important specification that is not a professional judge. It's just a honorary judge, a lay judge, a judge that has been, let's say, has been launched as a proximity judge, the soft face of law, a judge who is facilitating the dialogue between parties, applied to a field where there's no dialogue meant to take place, but just a validation or a refusal, just like a typical criminal scheme. Diego mentioned 72 hours for the validation. In Italy, slightly more, it's 4 days, 96 hours, 48 hours for the police to inform the judge and 48 hours for the judge to validate detention. These are the grounds for detaining someone. I just leave the list for your reading, and then of course can share the slides if anyone will find it useful. Here we go with the chronology, the time provision of detention. Usually maximum extension of detention is 3 months, as I mentioned before. But note that for those citizens of countries whose authorities struck a deal with Italy, with Italian authorities, signing a readmission agreement, this maximum length of time raises up to 4 months, 120 days. So that's the maximum amount of time. Straight from the directive, whenever there's no reasonable prospect of being deported, the detention has to be closed, has to end. Something which is not really taking place that quickly in real terms. Moving on to asylum seekers. The grounds are different because asylum seekers are people that cannot be deported throughout, as a rule, throughout the procedure of taking a decision on their application. But they can be detained in the meantime if one of the cases that you see listed in the slides do exist according to police and according to the judge, that in the 48 plus 48 hours I mentioned before has to validate the detention. So basically, if the person is considered to be a threat for the national security, if there's a risk of absconding, and so on. Again, I mentioned the same civil judge is in charge, but this time is a professional judge, is what we call tribunale. I mentioned before the maximum length of detention for asylum seekers inside removal centers is 1 year, which is a clear revelation of the punitive intent of the regulation. This detention can be extended throughout, not just pending the administrative procedure, but also pending the legal judicial procedure in cases where the application gets rejected at first and people do apply to the court, to the judge. So detention can last up to 12 months. So let me close the presentation of the legal framework, just mentioning that for asylum seekers detained, the national law foresees a fast procedure, strictly designed for these kind of applications, which should be completed, as you can read, in 9 days, 7 days for the interview and 2 days for the decision. Let me say that in a number of cases, the terms are not complied with, and it's still a bit unclear if the violation of these terms entails the release of asylum seekers or not. There's still some controversy in the case, especially in the merits decision. So it's still something that we have to understand, and judges have to understand. Now, I'm going to use the next final minutes to share some images of a pre-removal detention center in Italy, just to try to give you let's say really concrete perspective of what it is like to end up in such a place and to experiment the case of being detained. Carlo, can you see the picture of? Yeah, here we go. Right. Okay. So I guess this picture says a lot. There's no really need for much words on it. This is how one of the detention centers actually operating in Italy looks like. This is based in Torino, which is a medium-large city in the north side of Italy. The three-store building you see with yellow walls outside cages is the administrative building, where police, the management, and the doctors are working, while people get restricted in those caged areas. The walls are, the cages are 4 meters high, and every single area has a distinct perimeter of cages that prevent people from moving outside the area. It is interesting to know that for some, I would say, mysterious reasons, all single areas you see here, 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 and here, 6 areas, are identified through a color to provide, maybe to provide a different and lighter perception of the life inside these places. Every big room is divided into 5 rooms, each of which is basically 35 to 40 square meters. And every room is hosting up to 7 migrants. So they actually do share a quite limited space. They do sleep in the same place, and toilets inside and sanitary inside the rooms are not parted and separated from the rest of the area by door or any form of separation. So they're just open and communicating with the rest of the room. You see these smaller buildings inside the area are refectories, places where people are supposed to eat, but in most cases, these are not operating due to maintenance or damages. A lot of episodes of damages and fighting, I can surely understand you do imagine, are taking place in these places, and as a result, part of the places are out of order and cannot be operating. The last remark I would like to share concerns this place here. You see in the upper side of the picture, maybe you always see it here. It's a slightly different building from the others. You see, this is a small building made up of isolation cells. So places where people do live into 1 or 2 in numbers, not more. Interesting thing from a legal perspective is that there's no law allowing isolation inside detention centers. And I was mentioning before the architecture of this place. This place was, of course, a military barrack. At first, so it was converted into a pre-removal detention center. You see, these isolation cells has basically no direct connection with the sun, with the sunlight. So here you see the roof, and here you have a sort of roof cage that prevents the sunlight to enter easily into these places. This place here is the place where 2 people died in the last 3 years. The second committed suicide last year, and as a consequence, a number of rallies and events took place. This took place in front of the local head of government representative. A number of lawyers showed up with their with the dress, with the toga, asking for the closure, for the, let's say, abrogation of at least of the local detention center that proved to be completely not complying with decent living standards. The actual result that was achieved was that the isolation cells have been shut, so they're no longer in use since last year, summer 2021, but the center itself is still in operating with a different management. So last remark for you is to, if you're interested, to go online and look for the Black Book on Pre-Removal Detention Center in Torino. It is light leaflet, let's say 20 pages booklet on Torino Pre-Removal Detention Center, the place I showed you in these slides. And it shares some interesting and really dramatic trajectories of people that ended up in this place, and a number of critical points that pushed us to ask and to claim for the closure of the center. So this is available online. It's a free publication. So I would be more than happy if any of you could have time, actually 10 minutes, to invest on this booklet. I'm sure that you will find a lot of interesting information. So I guess I'm going to leave it here and pass the floor back to Carlo. Thank you.
Thank you, Maurizio. And I think it would be nice if you share the link to the leaflet, to the booklet in the chat.
Sorry, Carlo. It's easily accessible if you just type Black Book CPR. That will be enough. But of course, in case I can share it on the chat in a second.
Yeah, sure. And thank you, Maurizio. And I think that maybe later in the discussion we can say something more also about the research we did together, also with Ulrich Stege and other researchers from Italy, about administrative detention and judicial and the judicial control about administrative detention. We did this research in between 2013 and 2015. Unfortunately, the website is no longer online available, but in that research, we actually found out some data and figures that are quite similar to the ones that Diego was saying before about Spain. Let's say the rate of validation of detention orders, which is, so this, let's say, automatic mechanism of validation that judges basically don't do their work of controlling the legitimacy of detention. But let's leave it to the discussion. So I pass the floor to Bian for her presentation.
Yeah, thanks, Carlo. Let's start the presentation. Okay, so I think I can come back to some of the aspects that the colleagues have already mentioned, because I think quite a lot is similar, but some things are not. So I'll walk you through the detention system in Germany, which is called Abschiebungshaft in German. And here you see a map with the detention centers. The black ones had been already built and opened in 2019 when this map was drawn. The others, the light ones, were still being built. Some of them have opened already in the meantime. And the size of those detention centers is quite different. We have some that can take up to 200 prisoners and others that only take like 20. So it depends really on the federal state and the community and whatever. The numbers of detainees have risen during the last couple of years. So there were like 2,000 or about 2,000 in 2015, and now we already have nearly 5,000. So there were a couple less during the first pandemic year, but numbers went up after that again. Bit of history, the first deportation courts were already mentioned in the 1920s. So detention law goes quite way back in Germany and is kind of a pre-Nazi invention, I should say. And after the Nazi regime, part of the codes still stayed basically the same. They were then changed in the 1990s and in year 2000. And but we have seen a continuous tightening of regulations after 2015. So the reasons to put people into detention multiply. In recent history, we had a decision from the European Court of Justice, because Germany used to put people detained for deportation into the same prisons as criminal prisoners, and the European Court of Justice decided that this was unlawful, so they had to separate the prisoners, which has been mostly done now. And this decision also says that the detention must not be prison-like, so to speak. But we will see later that there's basically no difference between a penal prison and a detention center in Germany. Okay, there are different legal basics or types of detention. These are the two main types of detention. This is the so-called Überstellungshaft, which applies to people who fall under the Dublin procedure, and there is custody awaiting deportation. So these are the two main forms we're seeing. So the first one is allowed to be up to 12 weeks, and the second one is up to 6 months. And the administration can argue that exceptional cases need up to 18 months, but we seldomly see people in there for 18 months at the moment. So in former times, that was used more often. And then we have a couple of other reasons to put people into detention, but I won't go into detail there. Okay, oh, expulsion. I forgot the expulsion. Yeah. Okay, the requirements are obviously that the person is obliged to leave Germany. So all people who are in detention have run through the asylum procedure already and have been declined. So we don't have the cases you mentioned before, that people just that you don't have a clue about the identity of people and then put them into detention in Germany. And the immigration authorities must reason that there is a significant risk of flight, which is a bit strange as a formulation, as I feel, because people actually want to stay, they don't want to flee. So but there are quite a lot of indications for that. This can be because the person was unable to be found during former trials to deport them, or whatever, they have been uncompliant. So actually almost every reason can be given in order to put people into detention. Then actually in Germany, a judge must consult the refugee's file, because the detention requires a court order. Every kind of imprisonment in Germany requires a court order, so that also applies to detention. And detention must not be prison-like, I mentioned that already, and the detention must be as short as possible. So the immigration authorities must give reasons for the lengths of the detention they want to have. Okay, so that sounds actually quite good, doesn't it, in comparison with many other countries. I know many countries that do not even have the court order for the detention, and as we heard in Italy, that's a bit questionable as well, because they are not professional law judges. But actually, we have some statistic on the lawfulness of the detention, and unfortunately, we don't have any official numbers on that, because they're simply not collected, because administration obviously feels that if they count the numbers, it will be quite embarrassing for them. So we don't have any official statistics on detention in Germany. And to add on that, this is a federal system, and the federal states act a bit differently when it comes to statistics. So we don't have real numbers, the numbers we have, we draw from a lawyer, Peter Fahlbusch, who's the expert on detention in Germany. In the years between, or 20 years, he represented more than 2,000 people, and actually more than 50% were detained illegally. So if you try to challenge those decisions the courts make, quite a lot of them are illegal in the first place. And one of the colleagues mentioned that about 90% of the decisions are just what the immigration authorities apply for. It's actually the same in Germany. And on the average, each of Peter Fahlbusch's clients was imprisoned illegally for 26 days. So some of them just for a few days, other for months. We have a second expert on that who's called Frank Gockel, and he has he's also worked with several thousand detainees, and his numbers are the same. So we can guess that this is a quite good statistic. Okay, so the second problem is that we have inexperienced judges. We have heard that already in one of the other cases. So deportation detention is defined under a law that few civil judges work with. It's the so-called FAMFG, Code of Family and Voluntary Law, and nobody knows that. So it's something like an extra law for everything that doesn't fit in anywhere else. And neither the judges nor the lawyers are used to work with that. So especially the civil judges, because this kind of detention is not penal detention, and no criminal judges are in charge there, at least not if the procedure is regular. If there is like an emergency service, there are a couple of, but that's too detailed actually. So usually it's civil judges. Often new judges get the cases because they are absolutely unattractive. You can't make a career on detention cases. So actually experienced judges try not to get those cases. And the time designated for the case is much too little. We only have unofficial information on that, but on the average, like 3/4 of an hour is granted for such a case. And just the immigration file sometimes has like several hundred, up to 1,000 pages. So nobody can really say that they have consulted like several hundred pages in like 45 minutes and have heard the detainee and have written their decision and whatever. So this is a bit strange there. And so we have the same system here. Often judges just copy and paste what the immigration authorities have written, including the typos, by the way. So we can prove that because they really just copy and paste that, which shouldn't be the case. Oh, I've got two problems too. The first should have been problem one. Okay, so the second problem is we don't have a lawyer. Actually, in Germany, every person who is put into penal detention will have a court-appointed counsel if they cannot afford an own lawyer. But this does not apply to people who are detained for deportation. Because it's not penal law, but criminal law. It's this FAMFG I just mentioned, this extra law. And so they are not entitled to have a court-appointed lawyer. So the migrants are usually alone in front of the judge, and they always think that they have to argue for their asylum case, which is not the case. And if they say, I definitely don't want to go back into my home country, actually this is a reason to put them into detention, because then this is a risk of flight. Because they might try to get away from the deportation. Migration lawyers are also inexperienced with this type of law because, again, it's this extra law, and they simply don't learn that. migration lawyers, even if you have one, they are hard to find for the immigrants. So only we think about 10 to 15% of the people in detention have contact with a lawyer. Okay, so the factual conditions. Though we have this decision by the European Court of Justice, deportation centers still look and feel like prisons. And that hasn't changed after the decision. And we always complain about that, but we don't see any effect of these complaints. So the walls are 6 meters high, and we have barbed wire. It's the same as the pictures of Italy you just saw. And visits are extremely restricted. Women are only seldomly imprisoned before deportation. So in fact, they experience solitary confinement because there are simply no other detainees in there with them. Private communication tools are often not allowed, so many prisoners lose the contact to relatives, to lawyers, to whoever, to advisors completely. If they have medical conditions or are suicidal, this is treated, well, not according to what physicians and psychologists would advise. And we also have like isolation cells and everything you just heard about in the other presentations. Another problem is that detainees usually have to pay for their own detention. They don't have to pay immediately, but they have to pay if they are deported before they come back. So with the exception of Dublin cases, actually, and this costs like 300 to 500 euros a day, depending on the center you're in. So you have more expensive ones and less expensive ones. But if you calculate, you quickly get up to like 15,000, 20,000. Sometimes even more than 100,000 euros. Obviously, people cannot pay that, and so even if they have a valid reason to return, because for example, a German child is born or whatever, they can't because they first have to repay their debt. So in fact, if you've been in detention and you are not a Dublin case, you don't stand much chance to return legally. Okay, so what can we do? We have a specialty in this FAMFG, and this is a person of trust. So we don't have a court-appointed lawyer, but this is sort of a substitute for that. And it's a special role. Anybody can be named as a person of trust by the detainee. No formal qualification is needed. So you don't have to be a lawyer. You don't have to have studied law at all. No formal qualification. The detainee just has to say, this is my person of trust. This is special because in Germany, legal aid is absolutely strictly regulated. So this is the only case where you can work on such a basis in Germany. The person of trust does not represent the detainee. They do this in their own name. So they also have to pay for the court fees if they lose their cases, and so everything that's connected with going to court yourself. But almost all legal interventions are possible. So you can apply that the detention is illegal, and you can apply for everything actually, but just from the moment when you were appointed, because lawyers can act retroactively, but persons of trust cannot, which is sometimes a problem if we are not present at the first hearing, because then we cannot really challenge the first hearing, which is often problematic as well. So what do we do as a group, as an initiative, because I'm from an initiative that works with actually a clinic in which students work with detainees, And so we try to inform the prisoners and also potential prisoners if we get contact with them about their rights. Because in Germany, as you saw, looking at the numbers, only few of the people who are deported are imprisoned before the deportation. It's not much compared to the whole number. If you have 5,000 cases a year, many more people are deported without being imprisoned. So we try to get in touch with people who might get imprisoned before. So we try to inform them. We act as persons of trust, so people can name us, and as there is no restriction, you don't have to be a friend or family member, so we can do that. So we act as persons of trust. We review the documents because as a person of trust, you are allowed to get the files, also the court files and the immigration files, so we can review them. We write appeals to the court. We try to inform multipliers and the public. So we have like public information evenings and stuff like this. And we pursue the case even if the person has already been deported, because if we can let this case be declared illegally after the deportation, the person does not have to pay the debt. And it's also a matter of rehabilitation, because people often feel they are accused of a crime if they are imprisoned. So it's also a psychological effect we can have there. Yet we think we should have court-appointed lawyers, well-trained lawyers to do that if we do have to have detention at all, because looking at the numbers, it's so expensive. If you just look at the economical side of it, those centers are so expensive and so few for such so few people. So it's just a political signal. I think Diego already said that as well. It's we don't need those centers. It's just a sign for conservative voters that we are doing something against all those illegally present immigrants. Thanks.
Thank you, Bian. It was really interesting. I didn't know much about the German detention system, so I learned a lot. And I have an immediate question. Can I take advantage of my position to make it? How do you get in touch with the persons in state of detention to become persons of trust? Because this is, I mean, this figure of the person of trust is something that doesn't exist in Italy, and I think neither in Spain, as far as I know. So it's something very specific. And how do you get in touch? Because that's also a great problem in Italy, to get in touch with the persons inside.
Yeah, it is difficult, I must admit, but we are in touch with the social service in the detention center we're working in. So we're working in 2 detention centers. One is in Hamburg, but that will be closed by the end of the year. And there is a new one in a small town near Hamburg. That's now the place where also Hamburg detains their prisoners. And so we're in touch with the social services. So they talk with the detainees and ask whether they want to get legal advice from us. And we have a website, so and we hand out information material. So we try to speak with social services for immigrants and make them aware of the problem of the detention. So sometimes we get in touch because someone from a social service calls and tells us our client has been in prison, what can we do? And we can always get in touch if we have a name. So we are allowed to go into the prison or to get in touch with a person if we have a name. So if there is a family member and tells us that whatever, the brother was imprisoned and they don't know what to do, we can go to the prison and enter, and we get access in that case. We don't have like a open open advice sessions, which is something we would love to have, because other similar projects have that in other federal states, but we're not allowed to just go in there and talk with everybody who's there. But it is difficult, and if the social service doesn't bring us in touch with the people, it's really hard to get the contact. Yeah, so it depends, and this is also the reason why we cannot utter critique as fiercely as we would like to, because we don't want to block our access.
Yeah, I understand. Okay, there are a few questions. Some of them actually were raised during your presentations, so I think we're more specific, let's say. Okay, I think we can go through them from the first one. The first one is from Adele, and it's a general question to all of you. What are possible non-coercive alternatives to immigration detention? I think in the sense of, I mean, the alternatives provided by the law, I guess, not in, let's say, in a general sense, or how we could imagine different ways of dealing with this topic, I guess. I don't know if some of you wants to say something about this.
I can provide a quick line to this. Diego, you want to go? Looks like he's frozen. Okay. Just a quick line. Non-coercive alternative measure to detention are those provided for the national law in Italy and are basically taken from the criminal system, and consist of providing the passport to the authorities, complying with an order to show up at the police station, at the local police representative, and the ban of leaving the municipality or a special place where someone is living. Of course, going for an alternative measure means, to some extent, a measure of harm reduction, meaning that at least people are not experiencing detention with all this burden and consequences. But at the same time, the aim of alternative measure still remains deportation. So it is clearly a tool that the authorities could be considering. But in terms of defense, of course, I look at the whole issue from a defense perspective, which is somehow a bias, I understand. But in terms of defense, alternative measure is a good thing to avoid detention, but it still requires a lot of intervention in terms of lawyering and claiming for the foreigner in order to avoid the deportation. So if there's still space for an appeal and for claiming for suspension or removal of the deportation order, that's a different thing. Non-coercive measures can still be implemented more, at least at the Italian national level. But the usual refrain from the public authorities is that they lack resources to implement them. So there is a provision which, in fact, is almost not applied. I'm not sure if that's the same case for Germany and Spain.
Yeah, actually, it is basically. I think one additional measure that would be possible, but is not really much better than prison, is an ankle tag. Some countries use that as well, but it's also quite invasive measure. So Actually, people report that it's not much better than being detained. Yeah, and same in Germany. Those milder measures are not taken often, and actually, immigration authorities should declare which milder measures they have tried if they apply for someone to be detained. But the judges don't have to check that, so it doesn't have any effect really.
Well, detention should be the last resource. So this is a general point. In fact, this is the use of detention in immigration issues is an anti-systemic point. In the fact, we have decided in a democratic state, the decision is that detention, that the deprivation of freedom of movement for a person is the worst penalty you should impose to the worst crimes. But in the immigration system, we have changed that. And we have decided to put detention not as a penalty, as a measure to make sure the deportation. So detention is not a penalty, in fact. Here it's used as a way. So this is anti-systematic in the sense of our concept of penalties in criminal law in democratic state. So the most important thing is not that which are the alternatives to detention. The most important thing is that detention should not be an alternative. So this is the first point. So you have other possibilities. So in fact, as Mauricio said before, in the Spanish system, that's the presentation on a police station, the deportation of passports. Also, you could use another strategies as electronic devices to control the position of a person. So anything, but not detention. But the fact is that detention is not an instrument. It's a symbolic point, as we have said before, to establish that we are doing something, and that also that establish that people that are coming are dangerous, because it's also very important to separate between nationals and non-nationals.
I think we cannot stress how important it is what Diego just said. There is even a term for that. It's called crimigration, in order to make clear that migration has somehow shifted near to a criminal act. And that is development that has taken place during the last, let's say, 20 years, and it's so dangerous. And I think we cannot say often enough that that we cannot just put people in prison because we want to perform an administrative act, and deportation is just an administrative act. Yes, very, very important what you just said.
And I think that the consequence of these discourses is that administrative detention centers cannot be reformed and must be abolished. So there's no way in fixing the system and make it better, no? So I move to the other one, to another question. Natalia asked, can you mention where are the women rooms? There are separated places to women. What happens with people under 18? So basically children. So sorry if you mentioned it before. Okay, I think it's also this is this issue of women and minors is dealt in different ways in each countries. So
well, in Spain we have some detention center for women. They do not do not use the same detention center for men. Well, in fact, are part of smaller parts of the detention center because women are less detained. So this is the first point. So it's true that in this sense the system is not thought about, for women. So thought for is designed for men, and there are some issues about that. So it's not well, there are some criticism about this point. And for people under 18, for children, Spain does not detain minors. So it's not possible to detain minors. In this sense, we do not have this kind of system. It should be possible to detain minors with parents, but it's not. Spain doesn't do this in any case. So it's not, there are no places for minors in Spain.
Bien.
Okay, so it's a bit different in Germany. Actually, you're right. Also in Germany, the system is designed for men. But we have a couple of women in detention, but in many of the detention centers, they have like different buildings. And usually women are then detained in one of the separate buildings. So, but it's just few detention centers where detention for women is possible. But it's different with the children. Actually, in Germany, if you are in a criminal prison, there are special facilities for women and children, but children are only allowed to be in those facilities until they are 3 years old, because after that, people say that children understand that they are imprisoned, and they should not be psychologically actually punished for their parents' deeds. But this is different in the detention, so there is no restriction. So parents can be detained with their children. It happens seldomly, but it happens. And in Glückstadt, which is the small town near Hamburg where we're doing our work, they're just building a family block. So obviously they are planning to detain whole families there. Yeah. So it's even worse than in penal detention.
Quickly on Italy, as well, detention is designed to be a men thing to some extent. We only have one deportation center in Rome, which hosts a separated area for women. There are no places, no detention centers with family spots where people can be detained as a family. On minors, the issue is quite interesting because, as a general rule, the law forbids and prevents the deportation of any minor, anyone below the age of 18 years old. So, as a consequence, no minor can be detained. But what is actually happening in real terms is that for those not being able to prove their identity and their age, they can undergo an age assessment procedure, which is quite controversial. And as a consequence, the law says that during the pending of the procedure, the person has to be considered a minor, and as a consequence should not be detained. But in real terms, what happens quite frequently, I would say, is that even if someone declares being a minor, and I mean, with a certain share of credibility, if I would declare myself a minor, of course, that would not be credible. But if someone does it and can be considered a minor, the age assessment procedure starts, and if they are in detention, they should be immediately released and hosted in specially designed reception centers. This is not always the case, and actually quite often we see people that claim to be minor in detention, what I can say from my personal experience is that the case law and judiciary protection of minor age in this sense is extremely weak and extremely poor. So from time to time, we hear information about people declaring and claiming to be minors, being kept inside the detention center, even if the age assessment procedure and decision from the minors court take quite a period of time to be issued. And during this time, the person should be released, while in real terms, it doesn't always happen.
Yeah, can I add something about Italy? I totally agree with Maurizio, of course. And there in real terms, there's also the problem of minors detained in hotspot centers, in particular in Lampedusa, so the small island close to Tunisia, let's say, where people have been detained for weeks, sometimes for a month or something like that in the last period. And there are many reports, and I think also like appeals lodged by lawyers, also from the same organization of Maurizio, complaining about these about the condition of detention of minors, which inside the hotspot facility of Lampedusa, which is completely unlawful. But this is happening because of the way in which the Italian authorities are managing the transfers from the island of Lampedusa to the mainland. So there's also this problem of a complete unlawful and detention, de facto detention in the hotspot of minors and all the people, because that's an unlawful practice that's involved all the people that are there, also the adults. There's a question about if also other countries rather than Germany provide basically that people detained must pay their stay, must reimburse the state for the detention period into pre-removal centers.
Not in Italy. Not in Italy. This is happening with criminal detention, but not with administrative one.
I don't know if it's in Spain. People
no, and not in Spain. Spain is not possible that, and
yeah, I think this is one of the, let's say, some of the aspects that somehow differentiate administrative detention and criminal detention in Italy, for example. And I go to the last three questions very quickly. What kind of enterprise and what skills do employees of CPRs, of detention centers, usually have? What kind of people work there? Only police guards? So which is the, let's say, the staff employed in detention centers?
In Spain, they are only police guards. So it's very, this is a very important issue because, for example, in prisons, there are social workers, there are people with the specialization of a relation with prisoners. So this, but in detention centers, there are only police guards. So it's there are not other point of view except that of the security of the of policial point of view.
Okay, in Germany there are no police guards in the prisons, but it's prison officers. So actually it's basically the same as in a penal prison, and there is private security as well. And we have a couple of social workers, depending on the prison, how many and if at all. But it's basically prison officers. Yeah.
I think this is a great question that tells a lot about the perspective and the attitude from the public authority. In Italy, we do have police guards, a number of course, the same security model is implemented, but we also have limited number of people working for the management of the center under a convention after winning a tender, a public tender with the public authority, receiving money, making money out of this work. We had the chance to speak with a number of people working as a, let's say, or a linguistic supporter or a linguistic mediator or legal counselor or psychological supporter inside the camp. And some of them provided us with a really effective image of being the handkerchief of the system, being those who do the dirty job. Like, for instance, when someone has to be deported, usually police and the responsible of police has no clue who is this person. So they go to the, let's say, the operator and ask him to point who is Mr. X and Y. And of course, most of these operators are non-Italian natives, but are foreign people themselves. And they tend to be in a very, very risky line of being identified as the, let's say, those supporting the state against their own nationals. And whenever something critical happens, like people trying to commit suicide or to wound themselves or to harm themselves in order to gain freedom, they are playing a crucial role in speaking with people and at the same time in referring and reporting to the authorities. So they really move into a gray area of uncertainty and riskfulness for themselves. So I believe that this is usually ignored side of the story that should be at the center of the discussion much more than what the share that it receives now.
So another question was if we can argue that there is a link, a causal link between the over-securitization of migration and the concept of crime migration. I think it's I think there's a it's not spelled well. In what practical ways could policymakers move away from such a discourse, for instance, to a more human-centered approach? That's not an easy question. I don't know if Diego wants to say something about the link between criminal law and detention.
That is a philosophic question, more or less. So, well, it's true. We have built a concept of migration linked to security, to danger. So the others are always dangerous. So in this concept, that it's the whole system, from the moment that we build the European citizenship, we have to exclude the other people of this area, of this Europe fortress. So in this sense, the concept of policymaking is avoid people coming here. But it's not true, because there are other points, other important points about the needs of our societies, the position of our economy. So also the inequality between our area and Africa and other points of the world. So this is this speech linking security, not only crime, affording the issue of migration as a security point is important to build this discriminatory system. So perhaps we should change a lot of things about that, but also respecting asylum seeker, right to asylum, creating legal and secure pathways to come, not only for asylum seekers, also for economic migrants. Those are the first steps to change the way to afford this point, because illegal migrants, well, irregular migrants, are not voluntary. So there are not other ways to migrate. So because of that, they are here, or they are in our countries in an irregular way. So we should change this system to change the point of view about migrants. The truth is that we are doing the same from Maastricht Treaty. So we are doing the same. Even higher borders, less pathways, more detention centers. But the fact is that people is continuing to arrive, and we are violating their rights. They are. We have deaths at the Mediterranean. We have violations, but the position or the point is try to change the concept to do new things to obtain new results, because we are doing the same things and we are obtaining the same results.
I'm not sure whether your question also was what arguments politicians could use in order to change this narrative. And I think I'm afraid that the only argument will be economic benefit. I think most voters will not accept that it's just a humanitarian actually thing that we have to take those people, and that who are we to decide who lives where. So this would be the philosophical answer. Those borders are just imaginary, but I think if you want to catch the voters, you must argue with economic benefits, and there are even studies about that even the ones we don't want to have in our countries, even the illegal immigrants, even the people who come for economic reasons, if you give them the chance to become part of the community, they will bring more than they cost. So I think this is a simple fact, but nobody wants to listen. I think it would be easier to convince people if they see that they benefit themselves from the arrival of new people. But it's just hard to convey.
Just one line. I see, of course, it's a very big question. I see what Diego and Bian were saying. On the one hand, you had a very strong and selfish argument of providing and complying with people's expectations, the most egoistic and selfish expectations of saving money, of having people contributing to the welfare and the social system and so on. On the other hand, you have, let's say, a more a higher perspective in terms of fighting for a real establishment of people's rights, which of course requires, let's say, a cultural shift, a cultural leap into a different dimension. Maybe a combination of the two could prove to be effective. I believe the lawmaker is somehow a sort of antenna or interpreter of the feelings of the community that's behind him. So if this, I'm not aware of how many people is connected, but if the number of the audience was 10 times higher or 100 times higher, maybe we may be able to detect that something is changing. And the ideal would be to let the lawmakers receive the signal that something is changing, and that a more pragmatic and respectful policy would be possible. Then I believe something could change. I'm not really optimistic in this sense, but I'm trying to be.
Yeah, I mean, being optimistic from Italy in this moment is like a bit difficult. I agree with Maurizio. And I think that the most important question for us, point for us, is how to challenge these approaches and these policies, rather than thinking how to make the lawmakers, the whatever policymakers change their mind and their approach. Let's challenge them on I mean, their approach and these policies. That's what we all do in our professional and activist life. Other questions and arguments and comments are coming. Let's try to wrap up, because we're running out of time. There's a comment, I would say, rather than a question, from Abu Bakar, because he says, like, does Germany really have detention centers? Because people often are being raided at night, and the next spot they will find themselves in is inside the deportation plane. So I think the point is that there's an immediate transfer from police stations to deportation planes.
Maybe I can clarify that, because we have both. We have people who get raided at night, and it's often people who are in like refugee accommodations, and then the police arrives at night and just drags them out of their beds and puts them onto a flight. But often people are not at home when the police arrive, so they often do not find them, and so these are cases where police tries to put people into detention, because often you cannot just put someone on a plane. There is quite a lot you have to do before. You have to organize the flight. You have to organize maybe some medical assistance for the flight, depending on what the person's situation is, and this is often not realizable if the first trial to get someone out has failed. So it's often people who couldn't be found in their flats, in their accommodation, and actually it's often also people who live in just normal flats. It's not just people who are living in refugee accommodations. Many of the people who are detained, they work, they have flats, they have families. So and then the situation is quite different. And so yeah, both is right. Yes, people are dragged out of their beds at night, and we have detention centers. Yes. And not, if you look at the numbers, we have in normal years, if it's not pandemic years, we have about 20,000 people who are deported a year, and only about 5,000 are in detention centers. So I think this explains it.
And Lauren has a question for Diego. She says, I attended the course de Recho de Asilo at USAL. Is there a way to, so she knows the situation of asylum and immigration law in Spain. Is there a way to improve the situation of CS? Because the police is asked to do activities for which they are not qualified, and also there isn't a clear legal regulation and a lack of guarantees for the people inside the centers. I think Diego is stuck. Maybe we'll answer later. And then there's a comment by Luke, which is, of course, a very difficult point. Ah, okay, Diego, okay, you're back.
Okay. So I said that the best way to improve the situation of the seas is closing them. So is the point. So we can do some things to change, but it's only fixing things. But it's true, for example, that it's not logical that there are only police guards there, because they are not trained to attend people in detention centers. So this is the first point, changing the logical. But the regulation, I think the regulation is clear in this sense, but the point is the regulation is not good. And there are some points that should that have to be improved in this sense. For example, asking for asylum, there are some judges that have forced detention center to allow people to ask for asylum there in the sense of the directive. Also, the control, the possibility of NGOs to enter into the detention center to check the situation. I think it's also very important for us. We don't have some of the problem that there are in Germany. For example, there are lawyers, there are free assistance for migrants. So the points that we have covered, it's not the best situation, but I think there are lots of things to do. But the main point is that detention center, because of their design, because of their role, because of the people that are sent them, must disappear in our system.
Okay, last question, and which is a very, let's say, difficult political question. Luke says, I understand the argument that we should convince people that each migrant brings more to any country than it costs, but what would you say to people that are afraid for overcrowding? Because this is a pressing issue in the Netherlands, and it's a frequently used counter-argument.
At least for Germany, that's easy. Our population is shrinking. So this argument is used by some people, but actually it's not valid to my mind.
Yeah, and actually the European population is shrinking, not only Germany, and there are shortages of labor force in basically all the key sectors of the economy. But I'm not comfortable with this kind of let's say of approaches to the topic of migration, because I think that this functionalist approach are very tricky and a bit racist also, from in the sense that we understand people, we deal with people as they were, like, I don't know, economic factors or something, and instead they are people with rights and also with desires and goals in their life that should be respected. And I also think that these counter argument of we cannot welcome everybody, no, this is the argument, we cannot welcome all the world here, is a straw man argument, because there are not, like, I don't know, billions of people wanting to come to Europe. And also, of course, there are other ways in which, for example, Europe and Western countries and Western, let's say, economic actors also, let's say, affect the life of people in other countries. And so we should first probably stop affecting the lives of people in other countries before complaining for how many people come to Europe. But that's just my my opinion. I don't know if you want to say something about that.
Totally agree, but it's hard to explain to people who have a different view and who see refugees as a threat to their own wealth, which they definitely are not. So everything you said is just to be supported, but I don't think that those arguments will count for the people the participant has in mind.
Yeah, I think that's also a matter of narratives, in the sense that, of course, it's up to us to, let's say, to create and build and make strong counter narratives about migration, about asylum, and about these topics we are focusing in this course. So it's also important to be critical voices in public debates, of course, with all I mean, in the extent we are able to do it in these difficult times.
And actually, maybe we can encourage all the participants to talk about what they learn, and to be multipliers, and to bring the counter arguments and to convince at least one or two people. So you can all be multipliers, and you can all make a small change, and we all together maybe we can start a shift. But yeah, we just have to do it. So go out and convince people that migration is not what will kill us.
Okay, I think that we can close it here. We can finish it here. It's 8 o'clock, and we don't want to
sorry,
take
Carlo.
Yep.
Is a person that raised the hand. Probably she want to talk, but if we can allow her, or we have to finish.
Do we have other 5 minutes? I asked the speakers. Yeah. Okay. Happy to.
Yes, Casey.
Yeah, hello everyone. I'm sorry to hold you for dinner. I'm so sorry, but I just finished. First of all, thank you so much for this roundtable. I hope you can hear me well, but I really found it really interesting. And also, I've recently finished an internship in Brussels, so I came across a number of projects involving like many, especially African countries and EU countries, like having like these projects together to solve the shortage problem of the labor force in the EU. And I think I completely agree with the fact that seeing it as in the functionalist view is really problematic, because, for example, and I'm not afraid to say this, but I went to the final conference for the Match project by IOM, and I was so angry afterwards because they spent like 2 hours coming up with reasons why European employers wouldn't hire African like newly graduated students, even if they were like perfect candidates for the positions. And they were coming up with like different reasons, and which were obviously like, okay, good reasons, but no one of them in 2 hours managed to mention racism. And I'm talking about institutionalized racism, systemic racism, and racism in everyday life. And I was so angry. So I just wanted to make this comment, like to underline even more the fact that seeing it just like, okay, we can welcome them because we have a population problem, a labor force problem, is not the solution. And it shows that us as Europeans are still very like, have a very racist colonialist mindset. And I came across with it, and honestly, I didn't expect to find this type of discourse, but I did. So I just wanted to share. Thank you.
Thank you to you.
Was I mean, I think we all agree with your comment, and thank you for sharing it. So I thank you all again for being with us. Thank you, Maurizio, Diego, Bian. It was I think it was great. It was very interesting to me, and I hope to everybody. So hope to see you again soon maybe in person, and let's keep in touch.